Good afternoon. Today we're going to introduce legal liability. I'm probably the only accountant in the world that thinks legal liability is a good thing. Well, maybe not a good thing, but a necessary thing. When Lindsay was in college, we had a lot of conversations. One of the things I realized was she had a lot going on in her life. Some of it was very important. You have a lot going on in your life. I assume that if I didn't have tests, some of you would study less. I believe tests give you an incentive to study a little harder. I don't like tests. I hate grading them. But I test you to give you an incentive to work a little harder. Partners are human beings too. They have a life. They have wives. They have husbands. They have children. There are many evenings that they would rather go home earlier and attend their students' play or baseball game. And I believe that without legal liability, partners might be inclined to shirk once in a while. Legal liability provides them an incentive to make sure every audit is a high-quality audit. The book covers numerous cases. Here are the cases I want to make sure you study as you read. Ultramaris and Credit Alliance, Rush Factors and Rosenblum. The second restatement of torts isn't a case, but it's important, and I want you to make sure you look over it. Statute Law, Securities Act of 1933, Section 11. Section 10b-5 of the Securities and Exchange Act of 1934, and the Hochfelder case. So those are the cases I want you to focus on as you're reading the chapter. Remember, auditors can reduce information risk. We can improve the information and reduce the probability that decisions are going to be made off inaccurate information. We cannot reduce business risk. The probability that the entity, our client, fails to meet its objective, fails to pay its bills, or goes bankrupt. If any of those things happen, if a client goes bankrupt, it's very likely the auditor will be sued. Nobody likes to think they made a poor investment choice, and they're going to look for somebody to blame. The company doesn't have anything left. It's bankrupt, so the auditors are deep pockets which investors can turn to. Audit risk, this is a definition you should know. How close? Well, I'd say pretty close to word for word. The risk the auditor expresses an inappropriate opinion when the financial statements are materially misstated. Limited liability partnership, LLP. Remember here that partners are personally liable for their own acts and the acts of the others under their supervision. What does that mean to a partner? That means the partner's personal assets are at risk. The partner can lose his savings account, his investments. Okay. So the engagement partner and those people that work for him, the partner is at risk for their actions personally. Other partners are not liable for the negligent acts of other partners, but the engagement partner is. So they have a real risk. We need to separate and understand the difference between statute law and common law, breach of contract, tort, joint and several liability, proportionate liability, standard of care. I'm not sure that's a real word, but I use it, and so it's going to be real for the next 7 weeks. Privity of contract plus third parties with near privity. Common law deals with contracts and tort. Contract law applies when there's a contract between the two parties. The audit client has a contract with the auditors. Tort law applies to third parties. Investors don't typically have a contract with the auditor, so it will be tort law. Statute law, we've got the Securities Act of 1933 and the Securities Exchange Act of 1934. The Foreign Corrupt Practices Act of 1977 and Sarbanes-Oxley Act of 2002 effectively are amendments or additions to the Securities Exchange Act of 1934. When we talk about common law in our class, we're going to be talking about state law. When we talk about statute law, we're going to be talking about federal law. Understand that there is a body of federal common law, and states have their own statute laws. As it applies to auditors' liability, common law typically refers to state law, not always, and statute law typically refers to the Federal Securities Act, not always. In this class, all the examples we're going to talk about, common law or state law, statute law, or the Securities Acts. Thank you, and remember that there are multiple slide presentations for this chapter.